Is this Mr.
Cabinet, Your Honor.
Cavanis?
Yes, sir.
All right, certainly. Good to see you.
Is the court
You
ready?
may proceed.
All right. Thank you, sir. May it please the court, my name is Tyler Cavanis of the Knoxville Bar. I represent the petitioner appellant, J. William Edwards, and with the court's permission, I'd like to reserve 3 minutes for rebuttal, please.
Certainly.
All right. Thank you, Your Honor. Excuse me.
Three minutes?
3 minutes, yes, sir. Okay. Your Honors, Mr. Edwards' case, in this posture on appeal, I'm going to be focusing really on what I perceive to be deficiencies in the post-convictions court, I should say shortcomings in the post-conviction court's order on the post-conviction hearing. With respect to the issues we've raised, I believe that this court is in a position where remand is necessary because there are not adequate factual findings or legal conclusions related to the claims that were raised in the post-conviction petitions and also raised at the hearing. And that really comes down to two categories of claims in this case. The first is that trial counsel, I should say it this way. The first relates to Mr. Edwards' knowing and voluntary waiver of his right to testify, or the fact that it was not knowing and voluntary. That was raised in two ways before the post-conviction court. It was raised both as a standalone claim that the requirements of Momen versus State were not met, that there was not an adequate Momen hearing to establish a knowing and voluntary waiver from the record, and as a result, that claim in and of itself is a constitutional violation that would require relief. Secondary to that, Mr. Edwards raised that trial counsel was ineffective in not requiring a sufficient moment hearing to be held, and also not allowing Mr. Edwards the right to or the opportunity to testify on his own behalf. And then the second category of claims relates to a deficiency in the indictment and the jury instructions that were given at the conclusion of trial. I'll focus on the jury instruction issue first because I believe that's the category where the post-conviction court's findings were, I suppose, the most minimal. The issue in Dr. Edwards' case was that he was charged, relevant to this appeal, he was charged with count 1, especially aggravated kidnapping, count 2, especially aggravated kidnapping. Excuse me if I can grab my note or look at my notepad. Count 1 was especially aggravated kidnapping with a deadly weapon. Count 2 was especially aggravated kidnapping with serious bodily injury, just alternate theories of the same offense. And then count 3 was aggravated kidnapping as a standalone count, alleging that the victim suffered serious bodily injury. But the way that the trial court instructed the jury was that on the same page, counts 1 and counts 2 were, the elements of counts 1 and counts 2 were laid out. Count 1 being the complete elements of especially aggravated kidnapping with a deadly weapon, count 2 being especially aggravated kidnapping when the victim suffered serious bodily injury. As a lesser included offense on the following page, aggravated kidnapping was laid out to the jury. However, the instruction the jury received as to counts 1 and 2 and the lesser included version of aggravated kidnapping was only the element of serious bodily injury, not possession of a weapon during the commission of the kidnapping.
Wasn't these issues that you're arguing, weren't they addressed on the direct appeal?
They were, Your Honor, and I believe, I should say that from a strictly the application of the law to the record, they were, but not in the context of trial counsel's deficiency in failing to object to those issues. And on this appeal and at the post-conviction hearing, I believe the framework for that issue is that, or the the error and then the prejudice resulting from that error is that this court on direct appeal reviewed those errors, or reviewed the indictment issues for plain error. And so, for example, with count 3, which was the standalone count of aggravated kidnapping, this court in fact found that there was a constructive amendment to that count because it alleged both versions of aggravated kidnapping, even though it was only charged one way in the indictment. And so, of course, this court found that the jury was then permitted to convict Mr. or Dr. Edwards on a theory that was not alleged in the indictment. But under a plain error review, this court's ruling was, although there was a clear and unequivocal breach of the law, the court could not find that there was that the error necessarily impacted the outcome of the trial because the jury did have the elements of each offense, and the court on appeal under plain error review couldn't say for sure that the jury looked at the wrong set of elements in reaching or in convicting Dr. Edwards. And so I believe that the way that the issue was before the post-conviction court and is now before this court is that had trial counsel objected to the error in the indictment, or rather the error in the jury instructions, this court would have reviewed that error under a de novo standard, or that issue under a de novo standard on direct appeal. And at least as to the constructive amendment, I believe this court's law is clear that a constructive amendment is automatically requires reversal under de novo review. And so had trial counsel, so the argument on post-conviction is that trial counsel was deficient in failing to object to that error in the instructions. The failure to object to that error resulted in a plain error standard of review. Had that not happened, Dr. Edwards would have been entitled to relief at the very least as to count 3. This court very well, I believe it's likely this court on direct appeal would have reversed that conviction due to the constructive amendment of the indictment. But as to counts 1 and 2, the argument would have been that there was an improper instruction of the law based on essentially just the confusing way that these elements were laid out. The jury, within 3 different counts, received 3 different sets of elements for aggravated kidnapping, and there was no clear instruction on how that should be applied to the various counts of conviction. But again, because trial counsel failed to object to those errors at trial, this court was confined to a plain error review, and that's the resulting prejudice to Dr. Edwards. And so I believe that's the argument that I presented to the post-conviction court, and I believe that the reason remand is necessary at this point is because the post-conviction court's findings were really limited just to one page. On the first page of the post-conviction court's order, it set forth the 4 claims that it perceived Dr. Edwards to be raising in that hearing, and then it said that related to the indictment issues, those had previously been litigated on direct appeal, and the post-conviction court, in essence, would not disturb those findings. But the distinction I'm making is that, yes, they were ruled upon on direct appeal, but not with an analysis of whether trial counsel was deficient in addressing that issue and what the outcome of that deficiency could have been. And the post-conviction court here really just didn't make any findings. In fact, it fairly straightforwardly said this court will not be addressing those claims because they were already raised on direct appeal. And so I believe...
So I just want to make sure I'm clear. No ineffective assistance of counsel findings of fact were made by the post-conviction court as to this issue? I'm sorry,
Your Honor. I wouldn't say that. I would agree with the state here that the trial court did make credibility determinations about Dr. Edwards' trial counsel. Both of them testified at the post-conviction hearing. But I would say that because the trial court at the outset of its order explicitly said that it would not be addressing the claims related to the indictment issue and the jury instruction issue, none of those findings of fact, there was no conclusion of law related to those issues in the post-conviction court's order. And so I would say that the findings of fact really did not apply to that issue because the court just at the outset of the order said it would not be addressing them. But I do agree with the state that there were findings of fact made related to the Moment issue and Dr. Edwards' opportunity to testify.
And with regard to the Moment issue, the the post-conviction court hears that, are you saying that, well, first, I guess I have two questions. Are you raising a standalone challenge in post-conviction? And is that what you raised before the post-conviction court?
Yes, Your Honor, I am raising,
You raised both?
I'm raising both. Both that, so in the amended post-conviction petition, the first amended, and I could provide the court with the citation after I sit down, we did raise that trial counsel was ineffective in not permitting Dr. Edwards to testify, or I can't remember the exact language we used, but related to the failure, his lack of opportunity to testify. But in the second amended petition, and certainly in the argument at the hearing, and relying on both Momen but also Breer versus State, we are raising a standalone claim, or I am raising a standalone claim. And I know that the state has argued waiver related to that claim. And I guess as an initial matter, I would say that the state has waived its waiver argument. The state
Waive its waiver argument when you didn't raise it. I never really understood how that would work. How is the state supposed to waive an argument when it's not addressed below? I guess it's, I don't know how that works. It's kind of circular.
Well, and I think perhaps I misunderstood or didn't answer your question. My position is that I have raised a standalone Momen claim.
You raised it below,
Yes.
and you raised it on direct.
No, not on direct appeal, Your Honor. And so to then take a step back, my position is that the state has waived the claim that its claim that my issue is waived for failing to trying to not.
Waiver. Yeah.
I'm trying to not use too many negatives. I agree. The Momen claim, the standalone Momen claim, was not raised on direct appeal. The state argues that results in a waiver in the post-conviction proceedings. I believe the state has waived that argument now because it did not make that objection before the post-conviction court. And so I think that the state is not permitted to argue the waiver.
Does it matter whether the state raised it when the PC court could not have considered it to begin with?
I think it does, Your Honor, and I think the conflict in I believe there is a conflict in the law, or at least an uncertainty in the law. I agree with the state. The state has presented this court with authority, unreported cases as far as I've seen from panels of this court that do say that this is a claim that must be litigated on direct appeal. I agree with that. But then Momen itself is a reported case from the Tennessee Supreme Court, of course, that is a post-conviction case and examines this standalone constitutional claim without any reference to whether it was raised on direct appeal or not. And in fact, all of the language that Momen uses talks about the fact and establishes the fact that the failure to establish a knowing and voluntary waiver is of a constitutional dimension and of a fundamental constitutional dimension. And so I've also cited in my brief Breer versus State. That is an unreported case also from 2005, which was a year after one of the 2004 cases the state cited. And in that case, there was no analysis. It more closely followed Momen in the sense that there was not a proper Momen hearing, and the court really looked at that as an issue of, if there wasn't a proper Momen hearing, or the record doesn't support a proper Momen hearing, this is a standalone constitutional violation. And in the post-conviction context on appeal, reversed as a result of that. And so I recognize, and I think my position would be that there is some inconsistency or some conflict between cases from this court, but I think that Momen's the fact that wasn't an issue brought up in Momen at all, and that is in a post-conviction appellate context, I think that controls on this issue. My position would be that controls on this issue. And so getting back to your question, Your Honor, could the post-conviction court have raised it or even addressed this in the first place? I think it could have. I think that the state should have objected to this at the post-conviction court, and we could have litigated waiver at that point. And then just related to the standalone Momen issue, as I have laid it out before this court, I do think that if this court considers the standalone moment issue, the record does not support that there was a knowing waiver, and I would characterize the hearing as not being a moment hearing because the requirements of moment were not met. The final factor of the record establishing that the defendant did in fact acknowledge the waiver of his right, that just didn't happen in this court, or in this case, excuse me. What happened was after the state concluded its proof, the trial court and trial counsel went through a moment hearing on the record, or went through the stages of a moment hearing on the record. They got to the question of, Dr. Edwards, are you going to waive your right to testify? And the trial court said, well, we'll address this first thing in the morning. They get back to the next day of trial, and that hearing was never continued. There was never a finding on the record that...
But doesn't this ultimately become a fact question? Because what the post-conviction court did was basically weigh the credibility, assume basically that there was a conversation between defense counsel and the defendant, and that the conversation between defense counsel and the defendant resulted in the defendant not wanting to testify?
So I would agree with that in the context of the IAC analysis. My argument would be that if a standalone moment claim is properly before the court, then the legal question is, what does Momen require? Does Momen require that all of those four things specifically enumerated by the Tennessee Supreme Court, do those have to be on the record, or is 3 enough and we'll assume? I really think that I think that the argument on the standalone Momen claim is purely legal in terms of what does Momen require, and certainly then if there was a determination that substantial compliance was sufficient, then yes, there is a factual analysis there.
So at the post-conviction hearing, did trial counsel testify? While we may have not covered it all on the record, he and I had this discussion, and he knew that he had the right to testify and the right not to testify. Because as I read the record of the Momen hearing, it sounds like he was clearly told, you cannot be forced to testify. That part was pretty well set out. What seems to be missing is the part that if you want to testify, nobody can stop you. And that seems to be what he's complaining about now, not being told that. But at the post-conviction hearing, his lawyer testified, if I recall correctly. Oh, yes, we had those discussions. Is that right?
I think that's a fair, overall, I think that's a fair characterization. I think what Judge McMullen was pointing out is that if the trial court says, I credit the testimony of trial counsel, does that cover all issues, ineffective assistance, whether or not the Momen discussion was had? That I think that those findings, the way I see the distinction is if Momen requires there to be testimony on the record that the defendant is in fact waiving his right to testify, then that's not sufficient, because we don't have that here. We don't have that final question being asked of Dr. Edwards on the record. And as I've asserted in my brief and would say today, that's what Momen says. That's what Momen says those must be on the record, and that's a straightforward requirement. And so
it doesn't matter then that trial counsel testifies at a post-conviction hearing. Oh, we had those discussions off record, but we had them.
My position would be not under a standalone Momen claim. And so I have used my time, and we'll reserve the remainder for rebuttal, please.
All right, thank you.
Good afternoon, Your Honors. Abigail Renard for the state. This court should affirm the denial of post-conviction relief. First, the post-conviction court's findings are sufficient to facilitate appellate review here. And second, the petitioner waived his standalone Momen claim by failing to raise it in his motion for new trial or on direct appeal. And to the extent there was any error in the Momen colloquy, it was harmless. So first, addressing the findings. The findings here are sufficient to facilitate appellate review. Admittedly, they're not the best findings out there, but this court has concluded repeatedly that where a defendant cannot show plain error on direct appeal, he can also not establish prejudice in the ineffective assistance of counsel context.
I'm sorry, when you said admittedly the findings were not the best in the world. That's what I heard when it got to me.
Correct.
Is that
Yes.
right? And
Yes.
you're talking about the post-conviction court's order regarding petition for post-conviction relief, that order?
Yes, specifically the findings related to the indictment issue and the jury instruction issue. The rest of the order, I would argue, is very sufficient and thorough factual findings and conclusions of law, but that, as it relates to those two distinct issues.
And could you clarify that for us? Because in this case, was the trial court confused about its duty? Or can we tell that?
It's not clear, Your Honor. Perhaps it was confused. It seemed concerned with potentially contradicting something that this court had already relied on. Certainly, we would agree that ineffective assistance claims are obviously different from the direct appeal claims. So perhaps the trial court was confused. It's not clear entirely what happened there or why the court's findings are as they are. But we would argue that even though they're, not ideal, they are sufficient for appellate review here because there's no real factual dispute about what happened. So as it relates to the indictment jury instruction issues, there's no dispute here that the attorneys didn't object. This court found a violation of a clear and unequivocal rule of law, and whether that is deficient performance or not doesn't necessarily affect the outcome of this case because the petitioner cannot show prejudice, because this court found that although there was error, substantial justice was not at stake because it was not so significant that it would have changed the outcome of the trial.
And
So
that
even if-
that was a finding of the direct appeal.
That was on direct appeal, yes.
And so your argument is because a panel of this court made that finding, then that's going to overcome any prejudice argument that the defendant may later have at a post-conviction hearing.
Correct. And this court has found that in several cases. And similarly with the jury instruction issue with the white instructions, it's the same kind of issue where this court analyzed it for plain error and did not find plain error. And so because the petitioner cannot establish plain error in either of these issues, he cannot establish
Well, speak
prejudice.
to his claim that the review under the differing standards of review is in and of itself the prejudice. That's what I took from his argument. Does that make sense?
Yes, so I think that is, I think there's a difference though, because the claim would have been dealt with at the trial court potentially. I don't think we can assume that just because the petitioner didn't object then, that it would have been overturned on direct appeal and he would have gotten a new trial. I don't think that's what necessarily would have happened. I think he would have brought it up and the trial court would have said, oh yeah, there's an issue, or could have said there's an issue, and they would have fixed it then and there. I don't think it would necessarily have resulted in a new trial or a different outcome, which is why ultimately I think this court found that there was no plain error and found that the issue was not so significant that it would have changed the outcome of the trial. And if turning briefly to the moment issue as well, again, we would argue that the petitioner waived his moment claim. It's a standalone claim. He did not bring it up in his motion for new trial or on direct appeal. But even were it not waived, the court here in these findings did pretty much exactly what it's supposed to do under the circumstances. And it actually found that there was a moment violation here because based on the record, it's not clear that the petitioner personally waived his right on the record. But those requirements of moment and those procedures are not constitutionally required. And so the court is then proceeded to conduct the harmless error analysis that it should have. And it analyzed all of the four factors that are outlined in Momen. It discussed the importance of the defendant's testimony to the case, the cumulative nature of the testimony, and both of those it seemed to weigh a little bit less, but particularly important, it found that the presence and absence of evidence corroborating or contradicting the defendant. Here, the defendant would have claimed that the victim was lying, that the photos of her had been doctored, that she put on makeup to fake her injuries, and that she broke her own rib. And all of that would have been directly contradicted by the victim's testimony and by a lot of the evidence in the case that was corroborating her testimony. And the post-conviction court found that there was overwhelming evidence supporting the state's case here, and concluded reasonably that any error here was harmless.
Is it the state's position that a Momen problem or issue cannot be raised in a post-conviction claim unless it has been addressed in the direct appeal?
It could have been raised in the context of ineffective assistance of counsel, but as a direct standalone claim.
And that's, I guess, what I mean, a standalone claim. It's going to have to be raised in a direct appeal.
Correct. But,
Okay.
yes. And if this court has no further questions, we would ask that you affirm. Thank you, Your Honors.
Thank you. Rebuttal?
Thank you, Your Honor. To briefly address the, I guess, assumption that had trial counsel related to the standard of review of the indictment and the jury instruction issue, had trial counsel objected at trial, I agree. One possibility is the trial court would have realized the error and fixed the jury instructions. But it's also possible that the judge would have disagreed that there was an error, the error would have been properly preserved, and that constructive amendment would have then still proceeded to this court for review of that error. And it would have, the constructive amendment in particular would have been an automatic reversal under this court's law. And so I recognize what the state is saying there, but I think that the assumption that that error would have been fixed if there had simply been an objection lodged, I believe that's too speculative.
I think we're still getting, we're trying to conflate two things, and that's what's confusing everyone, because again, she came back with, and you can't ignore the fact that the prejudice, you look at the entirety of the case and the entirety of the evidence, and ultimately on direct appeal, we said the overwhelming amount of, proof in this case didn't require reversal. I understand what you're saying, that we have cases that say basically, hey, when this happens, it needs to be reversed. But again, I think we're conflating the two standards and the two contexts between direct and post-conviction, and that's what's causing a lot of consternation.
And as I think about that, I recognize the similarity between the prong under plain error review, that it would have likely changed the outcome of the trial, that very similar to ineffective assistance Strickland. But really what I'm saying here is not that it would have likely changed the outcome of the trial, it likely would have changed the outcome of that conviction on appeal because of the change in review. And I recognize what you're saying, Your Honor, about conflating those standards, but I don't think that Dr. Edwards, there must be something there, because it was trial counsel. My position is it was trial counsel's error that resulted in the harsher standard that then resulted in this court upholding his conviction. And so if this court finding that plain error didn't apply in that context, this is kind of a different type of error where I think we're generally on the same page that under a de novo review, that was an error requiring at least reversal of that count. We can attribute that error now on post-conviction to trial counsel's failure to object, to put it before the court, to change the standard of proof. And truth is, Your Honor, I agree there's some there's tension there, but to then say that Dr. Edwards just has no remedy because this court already found plain error did not apply, doesn't seem fair, for lack of a better term. But I've used my time. Thank you, Your Honors.
All right. Thank you, sir. Got one more. Call the next case, please.